everyone, I'm back again with a brand new video. Okay, you're in the kitchen cooking with Counting for Real. Welcome to my channel. Thanks for joining me. All you YouTubers, thanks for joining me on my accounting channel. So, well, today I have a little lesson. I have some long terms I want to run across past you. And then I have a couple of items I'm cooking on the stove today. First, I'm going to start out with a little dinner I'm cooking for me and my son. And then I have a couple of long terms I want to go over. And then I have a couple counting transactions at the end. So I want to get started. Okay, what I have here, these are the rolls right here. I'm going to just be cooking something small today. So I have some water boiling for my rice, and then I have some burgers that I'm cooking, and then I have some grains that I already cooked. So I cooked those a couple days ago, so I'm just going to finish those off. And these are my burgers, and they're just about done. Some hamburgers. And these are the hamburger rolls that I will be using. What I'll do once the burgers get done, then I'll take buns and toast them. And in the meantime, while my burgers are cooking, I have this is my cottage cheese that I had before. This is real good, Hood. It's a cottage cheese with peaches. And then I have a little bit of this left. This is cottage cheese with pineapples. So what I'll do, I'll just mix it together. See, I have a little bit left. So what I want to do, put that in there, mix that on in there. And since that's finished, So, and then I'll open this. And so, this is how it looks in the inside. Has a little bit of, I just need a little bit, just a little bit. And mix it in there. And so, put this in the fridge. Sometimes I think there's a cheese on it too. So, turn it down. So, do my burger. Cooking. And what I do, this is my water boiling. This is my rice. I have some rice. Throw a little bit of rice in there. And rice cook on down. And this is I'm gonna get burnt. Let me get my so this is my it's just about done. So what I do, turn my burgers down a little bit, so then when they get done, I'll probably put a little cheese on them. So when they get done, put a little cheese on them. And and this is my also, I always had this. This is my La yogurt smoothie with probiotics. So I always have one. I always try to have something to drink when I, These are so good. I usually buy, they come 4 in carton, so I usually buy about 2 or 3 of them, 2 or 3 cartons. You're going to get 4 in them, so that's like 8. Cheers. It's so good. I can drink these all day without eating anything. So good. And then this is my my yogurt mixed with my cottage cheese. Good. Okay, I'm butter down. And the cheese is so good. So what I do, sometimes I still keep my little seasoning and just put a little bit on your burger. Just a little bit on your burger. And this is for hamburger. That's for hamburgers, and sometimes you can just put a little bit of that on there too. Season up your hamburger. And then so I put my seasoning on my hamburger. And then also you can add a little bit of cheese. I use these on my tacos too. And this is, I said, my other video, I think it's like 3 different types of cheeses. So that's good. This is rice, little rice cooking. Can't see it, but let me see. Little rice. See the steam. Let cook a little more. And then the burger. I turned that down a little bit. So turn it back up a little bit. So what I do, this is my That's so good. That's the hood kind. A little fried. The only thing, as I said in my other video, they don't put enough fruit in it, but I guess you can put your own fruit in. Good. So I'm going to be going over a few little long terms shortly. So good. I just love this Lala drink. Love this Lala drink. And it looks like it has coconut in it. Oh, it made with real fruit too. Good for you. Yep, so, and then, also what I do, have your bread. See, butter your bread down. Butter your bread down. And I'm going to take these burgers out. done. Make sure they're done. So what I do, sometimes what I do is take the burgers out. Burgers out. And then heat up the rolls. Wash them ready, then get the popping. Yeah. Popping, get the popping, get the popping. So you have to watch them when they get the popping. So I'll take the burgers out for a minute and then I'll brown my bread. Rice is still cooking. So took the burgers out so I can clean the pan, and then what I want to do, I want to put my bread in and brown the bread. Take the bread in, so you take the bread, put a little butter on it, and let it brown. So I get no cheese on this and that, but sneezing. Oh, I need some hot cheese. So this is my yogurt. Excuse me. This is cottage cheese and yogurt. On my bread toast. Cheers. Nothing like a good burger. I don't eat too much meat. But I let the kids eat meat. I like turkey, baked chicken. I really don't like fish that much. I don't like fish, especially the ones with bones. And then a lot of that other fish that you buy in the store, it comes with so much grease. So I really don't buy it that much. So and then see, I how I brown my bread. Brown your bread, and then you have your meat ready to go on. Brown my bread like that, and what I do, the rice is almost ready. So we got burgers on our bread like that, and get another. Oh, excuse me. Bread like this. Only two. This is only two. Ha. So you put our burgers on the bread like this. So you have your toasted bread. You got your burgers on it like that. And then what I do a lot of times is so, and then what I do, and then your burgers on your buns toasted, and then you have your little bit of rice. Yeah. So what I do, this is the rice I use. So this back up in the cabinet, and I do also put a little bit of sugar. Put a little bit of sugar on the rice. We always eat our rice with sugar and butter. Yes, indeed. That's how I grew up. Sugar and butter on my rice. So that's the burgers. And ready. So cover up the rice. And those are the greens. Fridge. Alright. Okay. Okay, let me start my lesson. It's a little Sprite. Sometimes I do like to take a little Sprite and put it in my. Like you drinking? Mm-hmm. Okay. All right, let's get started. Okay, first I just want to go over a few of the terms I have. Okay, let's talk about I guess I want to talk about an administrative warrant. An administrative warrant allows civil inspections of private property to determine compliance with government rules, regulations, and city ordinances such as fine or building codes. Administrative warrants may also be obtained so government agents can conduct routine inspections when occupants refuse their entry. At times, the government has a compelling interest justifying warrantless searches for the public's benefit. Certain strongly regulated businesses may be searched during inspections without a warrant. In the United States versus Biswell, 1972, the Supreme Court reversed a court of appeals ruling that disallowed a warrantless search of a gun shop's locked storeroom. Which netted illegal firearms. The court stated that such inspections pertaining to the sale of illegal firearms are justified and that limited threats such as this to the gun dealer's expectations of privacy are reasonable, adding, when a dealer chooses to engage in this type of pervasively regulated business and to accept a federal license, he does so with the knowledge that his business records, firearms, and ammunition will be subject to effective inspection. So in other words, when you decide to open a gun shop, a gun business, so you automatically know that you're going to be subject to inspection. See, when a dealer chooses to engage in this type of pervasively regulated business and to accept a federal license, in other words, you have your business license to sell guns, you already know. It's just like if you have a business and you cooking food, or you mixing skincare products, hair care products, you already know that you're going to be subject to inspections because they have to know that the place is clean, especially when you're providing food and you're making food, you're selling food, making food, you have a kitchen or whatever, you automatically know that you are going to be up for regulations by the government and you're going to have to go through some inspections. And so, let me read up on this. It says searches with consent and searches without a warrant. The Fourth Amendment prefers a warrant because it necessitates judicial review of government action. Thus, the presumption exists that a warrantless search is unreasonable. So, in other words, a warrantless search is unreasonable, thus unlawful, and therefore invoking the exclusionary rule with the resulting evidence not permitted in court. But reasonableness itself dictates that action may become necessary before the government obtains a warrant signed by a judge. Such practical matters as time, emergency circumstances, or the probable destruction of evidence or escape of a criminal have resulted in legitimate exceptions being made to the general requirement of a warrant. In other words, if they feel that some evidence is going to be destroyed or the defendant may get away, so they don't have time, or they may fear for their safety or their life or whatever, so they might not have time to go get a warrant. So in those circumstances, that's why I say searches without a warrant. It says, such practical matters as time, emergency circumstances, or the probable destruction of evidence or escape of a criminal have resulted in legitimate exceptions being made to the general requirement of a warrant. Through the development of a case, the Supreme Court has defined the following searches without a warrant to be reasonable under Fourth Amendment guidelines. Exceptions to the warrant requirement include consent search, frisk, plain view, So in other words, if they come in your house or they looking in your car or whatever, and they see some evidence in plain view, the plain view doctrine, so it say plain field, plain view, or they see, in other words, if you get stopped for a traffic violation and the officer asks you for your license and registration, and he see that you have weed up on your dashboard, then that's right there in plain view. So incident to arrest, automobile exceptions, exigent, emergency circumstances, open fields, abandoned property, and public places. Searches with consent. If an individual gives voluntary consent for the police to search his or her person or property, the police may do so without a warrant. So in other words, if they see you and you standing around and they say, hey, they ask you for your license, they ask you a few little questions, and then they say, can I search you? So if they have to ask, then you have a right to say no. So hey, in other words, voluntary consent. While consent makes searching convenient, the downside is the person may revoke consent at any time. See, they don't tell you that. They're not going to tell you, but that's why I do a lot of reading. In other words, you can revoke consent at any time. You can say yeah, but then you say I changed my mind. I changed my mind. No, you can't search. You can't search me. Government agents may conduct a search without a warrant if they are given permission by someone who has authority to do so. Usually, the only person who can give consent is a person whose constitutional rights might be threatened by the search. This person is said to have standing. That is, the right to object to the unreasonableness of a search because of a reasonable expectation of privacy. Fourth Amendment rights are private and may not be raised on behalf of someone else or in some abstract theoretical way. Standing in constitutional law must involve a case or controversy. Consent to search an individual must be given by that individual. Consent to search any property must be given by the actual owner or, as set forth in United States versus Matlock, by a person in charge of that property. So, here's a couple of things I wanted to read. I'm not going to read all that. And here goes plain view evidence. The court recognizes that it would be unreasonable to expect police officers to either ignore or to delay acting on something illegal that they see. Hunsucker says it well. Anywhere a law enforcement officer has a right to be, he has a right to see through the use of any of his unaided senses. So if he have a right to be, he have a right to see. In other words, you call them to your home or something else, they get to peeping around and looking to see if they can see anything else while they're in your house. You could call them for somebody. Hey, somebody stole my tags, or I need to make a report because somebody, I saw somebody jump on my balcony and they jumped off, and now I'm missing some items on my balcony. So you call them for one thing, and they looking at everything. You call them for one thing, and they looking up at everything else. See, obvious qualify as plain view evidence if officers are engaged in lawful activity when they find the evidence and it is not hidden. Right, in other words, they can't come in your house, or I guess they're in your car or your house, and you have a briefcase and it's hidden. You have some weed in your briefcase, and they can't, because they don't have a right to make you open up your briefcase. In other words, that's what it said according to this. It says objects qualify as plain view evidence if officers are engaged in lawful activities and they find the evidence and it's not hidden. So if you got something hidden in, say for instance, like I said, a briefcase or under the seat or something like that, and they can't see it, it's not plain view. You got something hidden under the seat or in a bag or something, they don't have a right to go on your bag and they can't go up under your seat. Because it had to be plain view. That's what they call it, plain view evidence. Okay, so let me see. I'm trying to see. due process of law. Um, Due process is such an important concept of American law that no precise definition accurately suits it. It is the idea that basic fairness must remain part of the process. It is the right to hear and the right to be heard. In other words, you have a right to a fair trial. Procedural due process refers to how laws are applied. Those amendments contained within the Bill of Rights, the first 10 amendments are the Bill of Rights, apply to the criminal law, set forth the procedures that the government must follow. Procedural due process applies in both the criminal and the civil arenas, coming into play whenever government seeks to interfere with a person's liberty or property interest. I talked about the Miranda rights on my other video. Miranda is perhaps the best known, most significant law enforcement case ever decided. This case, because of its notoriety, has arguably done more to teach constitutional law to the masses than any other source. Excuse me. Most television and movie watchers can recite the requirements set forth by Chief Justice Warren in this pivotal case and understand that the purpose of the warning is to let the accused know that they do have rights and to protect themselves. Miranda is now without critics. So, just a few little things in this book. Okay. And then I have, actually, let me show you this book right here. It's what they call, that's what I'm reading from, Constitutional Law and the Criminal Justice System. So that's what I was reading from. And the next book is Criminal Law and Procedure. And these are the books that I had when I took a course. I have my legal assistant diploma. I have that, so I finished that. And I also have my degrees from Strayer University. So, and then this book right here, Criminal Law and Procedure, the structure of the court system. A trial court is a court that hears and determines a case initially, as opposed to an appellate court, a court of general jurisdiction. Appellate court, a court of appeals. In other words, you have a trial, you have a case, and the case over, and they find you guilty. So you want to tell your lawyer you want to appeal. You want to appeal your case, and so that will go to the appellate court. Trial courts are what most people envision when they think of courts. Trial courts are where cases begin, where witnesses are heard and evidence is presented, often to a jury as well as to a judge. And we had a writ of certiorari. A request for certiorari is like an appeal, but one which the higher court is not required to take for decision. It is literally a writ from the higher court asking the lower court for the record of the case. From the higher court asking the lower court. So the higher court asks the lower court for the records. I guess they want to review the case. So now I guess the higher court, maybe the Supreme Court. In other words, the Supreme Court probably want to see the records of the defendant. See, appellate court, a higher court that can hear appeals from a lower court. Then we have the duties and powers of the judicial branch. Of the three branches of government, attorneys and other legal professionals have the most interaction with the judicial branch. That's the court system. For that reason, we single out the judicial branch for a more extensive examination of its functions. Judicial review, a higher court's examination of a lower court's decision. So that's the judicial review. Comparing civil law with criminal law. Criminal and civil law, okay? In criminal law, the purpose is for punishment and deterrence. For civil law, the purpose is to compensate and deterrence. Remedies for criminal law, fines, restitution, imprisonment, counseling, rehabilitation, injunctions, capital punishment. And for civil law, the remedies are damages and equitable relief. So in other words, civil law and criminal law. In other words, the civil law mostly deals with like civil lawsuits, and then they want to compensate the victim to try to put them back in the same position that they were in before the crime happened. So it deals with I learned a term too called restorative justice. So that's a similar. I think that's a term they use in civil law too. So in other words, they want to restore justice. So you have to compensate the victim. Compensate the victim. Then it say criminal law. The parties are the government and the defendant. In the civil law, we have the plaintiff and the defendant. Standard of proof is in criminal law is beyond a reasonable doubt, and it's the preponderance of the evidence is in civil law. Then we have burdens. Government bears burden of proof in criminal law, but in civil law, plaintiff bears burden of proof. So we have damages. We have a contract and agreement that affects or creates legal relationships between two or more persons. To be a contract and agreement must involve at least one promise, consideration, persons legally capable of making binding agreements, and a reasonable certainty about the meaning of the terms. So in other words, you can't enter into a contract with a minor. Now if you enter into a contract with a minor, the minor can rescind that contract because they can't enter into a contract if they under the age of 21. So they can't enter into a contract, and you can't enter into a contract with somebody that's probably drunk or mentally insane or mentally incompetent. That's why it has to be competent parties. It has to be a meeting of the minds, mutual assent. So in other words, the offer and acceptance. Somebody offer you, say, paint my house, give you $2,000, you accept it, and you accept it. So the consideration is the amount of money that you're going to be receiving for painting the house or whatever, whatever you have to do. So offer and acceptance, you have a meeting of the minds, you both agreed, you both of sound mind. So that's what it says. To be a contract, you must involve at least one promise, consideration. In other words, and also a contract can be a promise not to do something. You can contract. In other words, somebody can say, maybe the government might say, "Hey, I got a contract with you for you. I don't want you to smoke. You can't smoke in your apartment building because it affects the neighbors. So you have the contract. You can't smoke. In other words, because it affects the neighbors. And smoke is going through the walls. It's going up to other residents' apartments. I mean, I'm just I don't know what type of contract that would be, but but it says I read in I think on my other books it said you can make a contract not to do a thing. That could be a contract too. So then you also have damages, money that a court order is paid to a person who has suffered damage by the person who caused the injury. So like I said, that's part of the restorative justice. In other words, somebody committed assault and battery and beat the person up, and they're gonna have to restore the person back to the original state that they were in before the person assaulted them. So you have to restore justice. So they have a right to civil damages, money damages. And that is considered tort law. It's considered a tort, and it's a part of tort law. Tort is a civil as opposed to a criminal wrong, other than a breach of contract. So a tort wrong is a civil, not a criminal. So tort is a part of tort law. I think assault and battery comes under that category. Then we have negligence, the failure to exercise a reasonable amount of care in a situation that causes harm to someone or something. So you were negligent, and you didn't mean to cause the harm, but it happened anyway. The failure to exercise a reasonable amount of care, so you didn't offer the amount, you didn't provide the amount, I guess, of due care. Intentional determination to do a certain thing, strict liability, a legal responsibility for damage or injury even if you are not at fault or negligent. So in other words, you bought some toys for Christmas, and when you open the box, something popped out and hit you in the head and put a burnt mark on your head, so you were injured. So then the company, the manufacturer, I think now, strict liability can be extended to the manufacturer, the wholesaler, and the retailer. So all three of them will be liable. So you open the box, and they didn't intend for you to be harmed, but the product that you ordered, it malfunctioned and it hit you in the head and burnt your head, or put a bruise or knot on your head and you had to go to the hospital. So that's how that is. And then we had the compensatory damages awarded for the actual loss suffered by a plaintiff. So in other words, compensatory, you have to compensate the victim. In other words, you committed assault and battery. Now you got to pay. They have a right to a civil lawsuit. Punitive damages to punish the victim. Punish the, not the victim, but the defendant. Punitive damages that are awarded over and above compensatory damages or actual damages because of the wanton, reckless, or malicious nature of the wrong done by the plaintiff. So, then culpable means blamable. Culpable, blamable, at fault. A person who has done a wrongful act, whether criminal or civil, is described as culpable. Bill of Rights, the first 10 amendments. Deter, to discourage, to prevent from acting. Retribution or societal vengeance is the fifth purpose. Simply put, punishment through the criminal justice system is society's method of avenging a wrong. Retribution. Then we have common law, the legal system that originated in England and is composed of case law and statutes that grow and change, influenced by ever-changing custom and tradition. Stare decisis, let the decision stand. The doctrine that judicial decisions stand as precedents for cases arising in the future. Precedent. Prior decisions of the same court or higher court which a judge must follow in deciding the subsequent case. In other words, common law came about, so when I studied, I took a business law class in Australia University. So common law came about, well, when the judges, back in the day, way before any of us were born, judges used to go down in the towns to decide, to resolve disputes. So when they resolved those disputes, those decisions became laws. They used that case. In other words, the judges made decisions. They let the decision stand. So in other words, stare decisis, let the decision stand. That decision became law, and those same decisions are probably on the books today. So when judges made those decisions, then when they went back again to solve more disputes, they looked at those same cases, which they call precedent. Not president, precedent. So they looked at those same cases, which made those cases important to helping them solve the next case. So that's what they call precedent, stare decisis, and that's how the common law came about. So in this book, that's what it is. That's where I'm at. Common law, stare decisis, and precedent. So just a couple little terms. Then we had the principle of legality. The question of whether common law crimes should continue to exist is debatable. Those who favor permitting common law crimes claim that it permits courts to fill in the gaps left by the legislatures when those bodies either fail to foresee all potential crimes or simply forget to include a crime that was foreseen. Lady can read, can't she? Lady can read. Due process clause. The due process clauses of the 5th and 14th Amendments to the U.S. Constitution require that no person be deprived of life, liberty, or property without having notice and a real chance to present his or her side in a legal dispute. Due process of law. Due process clause is basically your day in court. You deserve a fair trial. You don't deserve, not that you deserve it. That's the law. So they will have ordinances, a local or city law rule or regulation. We have a statutory law. As you have already learned, the legislative branch is responsible for the creation of law. You have also learned that legislatures possess authority to modify, abolish, or adopt the common law in whole or in part. We have ordinances, administrative law, okay, constitutional law. That's what this, now this is criminal law. The other book I had a constitutional. Then I have a civil law book too. Finally, constitutional law is concluded in this list of sources of criminal law, not because it defines what conduct is criminal, but because of its significant impact on criminal law generally. The United States Constitution, primarily through the Bill of Rights, is responsible for establishing many of the rules governing criminal procedure. So constitutional law that governs most criminal procedures. This has been especially true in the past few decades. You will become more aware of why this is true as you learn more about criminal law and procedure. Pay close attention to the dates of the cases included in this text. It is likely that many were handed down in your lifetime. This is a good book. So, something I never heard of right here. Breach of peace. A vague term for any illegally public disturbance, sometimes refers to the offense known as disorderly conduct. It is defined and treated differently in different states. And look, fighting words, speech that is not protected by the First Amendment to the U.S. Constitution because it is likely to cause violence by the person to whom the words are spoken. So it's not protected. So it's not protected by fighting words. Doctrine is another exception. So in other words, if you think you want to invoke your First Amendment rights, First Amendment freedom of speech, religion, freedom of the press. So if you say some words and you speaking those spoken words that's not a part of the First Amendment, then you're not covered by the First Amendment. You won't be covered by the First Amendment. Those will be fighting words. So disturbing the peace, threats, vagrancy, and panhandling. We have contempt. It's broken down into direct and indirect criminal contempt and direct and indirect civil contempt. There's so many different words here. Direct contempt refers to the acts that occur in the presence of the judge. Indirect contempt refers to actions taken outside the presence of the court. In other words, you somewhere else. That's indirect contempt, and you doing something against. That's just like when you go. It might also refer to, in other words, if you on jury duty and you're outside somewhere and the judge tell you don't talk about the case. Because I've been on jury duty before. So if you're outside of the courtroom, but the judge says, look, don't talk about the case, and you go and run your mouth and talk about the case, then the judge can find you. That would be indirect contempt. But now if you're in the courtroom and you running your mouth about the case right there by the judge, then that's direct contempt. So then we have something called intoxication. Refers to all situations in which a person's mental or physical abilities are impaired by drugs or alcohol. Then we have a mistake. Mistake is an intent to steal another property, an element of theft. And so no, people may be mistaken in two ways. First, one may believe that some act is legal when it's not. This is a mistake of law. Second, a person may not understand all the facts of a given situation. This is a mistake of fact. So in other words, you might not understand the ramifications of that case, and that would be a mistake. Then we also have entrapment. The acts of government officials, usually police or agents, inducing the person to commit a crime that the person could not have committed without the inducement. In other words, you would be entrapped if you are a law-abiding citizen, just like me. I know I don't smoke weed and I don't drink. So, in other words, if law enforcement or somebody trying to entrap me to smoke some weed, and no, I don't, and I never have in my whole lifetime, then that would be entrapment. But if they know you was going to do it anyway, that won't be entrapment. Then we have menswear, activewear. So menswear, when you're mentally thinking about committing a crime, activewear, when you actually go out there, and commit a crime. Then we have alibi, consent, statutes of limitation, federal statute of limitations set the time limit. In other words, a certain time limit on certain crimes. Statutes vary in length and serious crimes such have no limitation. Generally, the higher the crime, the longer the statute. Statutes begin running when a crime occurs. So this is a good book with some nice terms in it. So, and then I have a civil litigation book. So interrogatories are written questions submitted by one party in a lawsuit to another party. The responding party must answer. And then we have, and I can read all of these, so time, I like to make my video too long. Okay, so I think that'll be it for my legal terms, and I just want to go. Just want to go over a couple little accounting journals, entries, and ledgers. So in other words, repaired damaged fender on a truck. So in other words, if I repaired a damaged fender on a truck, it cost me $877. I would probably consider that as an expense. I want to debit my expense $877, credit cash $877, and then I have my little ledger account. I want to debit my expense account $877, credit cash $877, and then traded in service truck for I traded in the truck for $18,000. I wanted to purchase the truck for $18,000, but I got $5,500 off. So if I got $5,500 off for $18,000 truck, so I would still consider that as an expense. I want to debit my expense account. Expense. It could be a truck or expense equipment. So $12,500, and then I want to credit my cash account because it's coming out of the cash account, $12,500. And I paid $107 for replacement of one tire. So that's an expense too. $107. I want to debit the expense account $107. I want to credit cash because, as I said, credit when for asset account, you want to credit for decrease. So it's coming out the cash account. So I'm going to credit cash account $170. And then I paid $2,500 to have the truck engine overhauled. So that's an expense. I want to debit the expense account $2,500 and credit cash $2,500. And then I say I want to debit the expense account in my journal entry and credit my cash account in my journal entry. And then I paid $12,420 for a used truck. So I want to create it. I'm creating an asset. So that's $12,420. So I want to debit my truck account, and I want to credit my cash. Is coming out my cash account, $12,420. And then that's my journal entry. $12,420 on debit equipment, and I want to credit my cash account. $12,400. I want to credit my cash account. And this is the last one. Paying $180 to have the truck modified. This is an expense. I want to debit my expense account $180. Credit cash $180. And then I have my ledger. my journal. This is my Legend is my journal. Okay, so expense, debit expense $180, credit cash $180. I think that's the last one. So I think that's it for today, class. And I want to say thanks for joining me today. Also, my previous video, as you can see, I already finished everything. My rice is finished. My burgers, they all finished. And so I want to say thanks for joining me today. And I already put the food on the table. So thanks for joining me. And hope to see you back here again. Same time, same place. Accounting for Real. Cheers. You all have a good one. And in my previous video, I was talking about my accounting information system. So I thought I'd branch off of that for today. I might get back into that probably on another video. So I'm building an accounting information system for my building. I need that vital information to come in. I have my networking professionals working, and I have 50 buildings. I have 100 buildings, and I have a certain amount of offices, and I need those accounting information systems. I have my manager. My managers are going to be there when I'm not there. They need that vital information to make decisions. They need to make decisions within the organization because that's managerial accounting. And then I have to deal with financial accounting because it's my business. I'm the owner of the business. I have to deal with financial accountants, financial accounting. I have my auditors, my SEC, Securities and Exchange Commissions. I have my banks, my credit unions, because 9 times out of 10 I'll be needing a loan somewhere down the line. And so I might want to branch off. I might want to expand. I might want to expand my product line. I might want to hire new employees. I might want to hire more employees. I might, like I said, expand my product line. I might want to put a new branch on, a new wing on my existing business. And so, class, I'm gonna close out today because it's almost an hour. I think I have about a minute and something left, so it'll be an hour for this video. But thanks for joining me, and I hope to see you back here again. Same time, same place, same channel, Accounting for Real. Now I want to be presenting more cooking segments. So I want to do some baking and whatever kind of recipes that I see fit that I want to bring, to you. I think that's interesting. Then I will bring them. Making cupcakes, whatever. I'm just trying to explore. I love to cook. I love my accounting. I love my business. I love to cook. I love to eat. I love to bake. So those things are interesting to me, and I hope you are enjoying these videos. So can you please subscribe below? Give me some suggestions of what type of recipes would you like to see? What type of accounting would you like to see? I mean, I've done a whole lot of debits and credits and balance sheets, statement of owner's equity, and trial balances. So I have about 60 videos out there now. I have about 60 videos. So, class, I want to say thanks for joining me today, and please comment below, subscribe, and give me some ideas. I value your comments, and give me some ideas on some recipes you might want to see, accounting tutorials you might want to see. And so I hope to see you back here, same time, same place, same channel, Accounting for Real. This is Cheryl Arlette Hubbard Walker signing off, and I want to say to you all you YouTubers, you all have a good one, and I'll see you next time. So have a good one. All right, signing off.